Hello everybody and welcome to week 6 of Ethics and Accountability in Forensic Mental Health, and today's topic is confidentiality. This lecture will be viewed by students across Australia, and therefore I would like to acknowledge the traditional owners of all of the lands throughout Australia. I would like to pay my respects to the elders of these lands, the elders who have passed, and the elders still present today. I would like to acknowledge the hardships suffered by these people across Australia and hope that the material within this lecture is sensitive to this. So, to provide an overview of today's lecture, first of all, we will be making an introduction to confidentiality. We will talk about the factors affecting confidentiality, the legal, regulatory, organisational and ethical considerations in regards to confidentiality, what some of the exceptions are, both legitimate and illegitimate, when thinking about confidential matters, and what are the implications for practice. So, a definition of confidentiality. Confidentiality refers to the duty to refrain from divulging private information held in trust. It is closely related to the moral notion of promise keeping. Confidentiality is based upon the principles of autonomy and justice. That is, the client's right to have control over their own information, and where we as professionals demonstrate our respect for our client's dignity and rights. A person who is party to sensitive personal information effectively places himself or herself under a moral obligation not to reveal that information to others. The importance of upholding confidentiality rests upon what it represents. Just as in the case of promises, confidentiality is a kind of contract of mutual trust between the client and the mental health practitioner. When we think of who a client is, they might be someone who receives the services we provide, a third party who pays for a service to be delivered to a person, and/or an organisation who contracts the service. And because there are these different definitions of client, the duty of confidentiality is not as cut and dry as it may initially seem. Confidentiality is distinctive for a number of reasons from an ethical point of view. So firstly, it marks out a special kind of relationship between two valued people, and it is used to establish a relationship of trust and safety with our clients. There are a number of reasons for valuing trustful relationships. Through them, bonds with others are maintained and respected. It is a contract between people where one gives the other valued information, entrusting they will keep it secret. It marks out the special role that information can play in relationships between people. In particular, it signals the fact that information generates power, and what is known about individuals can affect them in ways that are good or bad. And confidentiality is a recognition of the care that a person must take when given such power. And so it also emphasises particular behaviours that are valued in a society. So confidentiality means exercising certain dispositions, such as self-discipline and being trustworthy. By respecting client confidentiality, the mental health professional shows that they value these dispositions. In both the moral and professional contexts, trust and trustworthiness are closely associated with the maintaining of confidentiality. Every client should be informed of his or her right to confidentiality and informed about the limits of it. That is, under what conditions will confidentiality be breached. And given the nature of forensic mental health, informing clients at the outset of the limits of confidentiality is essential. So confidentiality is not absolute. Sometimes we will need to consider different factors in making a decision to maintain or breach confidentiality. Some of these factors include capacity. So the capacity of the client, remember, as discussed in last week's lecture, refers to the quality of being capable, competent, or legally fit to make decisions. Informed consent is agreement to a proposal with an understanding of what is involved and without coercion. So the ethical foundation of these concepts is autonomy and the right to self-determination. So other factors include who has the legal authority to make decisions for the client, what the legal status of the client is. For example, are they a prisoner, are they under a forensic order or an involuntary treatment order? The client's age. So for example, a young person may be considered capable of giving informed consent in Australia when he or she achieves a sufficient understanding and intelligence to enable him or her to understand fully what is proposed. And this law in Australia was stated by the High Court. Other factors include the vulnerability of the client, whether there are multiple clients. For example, there could be a third party paying for a service, or therapy may involve more than one direct client. And the effect of the client's decisions or behaviours on themselves and or others. For example, a risk of harm to the client's self or a risk of harm to others. And also some of the legal requirements for disclosure. For example, if subpoenaed by a court or when there are mandatory obligations to report. For example, Queensland employees in certain departments are required under the Child Protection Act to report the maltreatment and abuse of children. So what do we need to consider when maintaining or breaching confidentiality? We will firstly have to consider the legal obligations of our jurisdiction and our profession that govern the maintenance of client confidentiality. Nextly, we have to consider the regulatory bodies that govern our professions, depending on which profession that is. We also have to work within the organisational policies or those of third parties that affect our maintenance of any client information. And then throughout this process, consider our ethical obligations. And lastly, there are ethical principles that inform each of these components, whether that be the principles that underlay the laws that we need to abide by, the regulations, for example, set out by our registration board, or the policies set out by our workplaces, whether that be in the public or the private sector. So in this lecture, we will talk about our ethical considerations, the necessity of maintaining client confidentiality, and the exceptions to this, including the duty to warn. And we will assume that the common definition of client is the person who is directly receiving the service unless specified otherwise. The principles that underlie client confidentiality are the principles of autonomy and justice. So through the respect for the client's right to decide what happens to them and their information, and that these decisions be fair and equal for all. So there are many ethical issues associated with confidentiality in healthcare, and this concept began with the Hippocratic Oath, written in 460 BC. And a survey of members of the American Psychological Association reported that ethical dilemmas most frequently experienced by practitioners as troubling were around the issue of confidentiality. And in the forensic mental health area, there will be situations where there may be requirements to break confidentiality, either by law or in accordance with professional judgment. So legal requirements will be relevant in each jurisdiction and for specific professions for the protection of client confidentiality. For example, there are principles of common law that need to be considered. These are judge-made, and these generally require mental health professionals to maintain confidentiality, and clients generally expect a confidential service. So these come from laws of contracts, torts, and equity, where the mental health professional and the client enter into a contract even if one isn't signed, through the fact that the client is seeking treatment and that there is a professional offering to help and expecting payment. Implied in this contract is the expectation of confidentiality. So upfront discussions with clients about the expectations of confidentiality are extremely important. And specific written or oral agreements on the nature of the professional and client relationship can help to clarify the obligations. Other legal requirements are civil law requirements, and this refers to when an action of one person is taken against another person or organisation seeking compensation for loss or damages. And there is also the public law or regulatory legal requirements that need to be considered. And these include state as well as federal mental health legislations. So we introduced the Tarasoff decision case in week 4, where we considered the duty to warn from a utilitarian perspective and how it underlay the Tarasoff decision. So let's just have a reminder of that case. So in 1976 in California, the issue of confidentiality was considered with the Tarasoff decision that established the clinician's duty to protect third parties from their patients' foreseeable violence. So in this case, a student attending a University of California clinic told his psychologist of his intentions to kill a young woman whom had rejected his romantic advances. The therapist informed his supervisor and the police. However, the woman was not warned on the basis that the communication was privileged. The student subsequently shot and stabbed the woman to death, and her parents successfully sued the psychologist and the university for negligence for failure to follow a legal duty to breach confidentiality. The Tarasov decision specifically compared the competing principles of confidentiality and public protection and determined that when there is a clear and imminent risk to an identified person of serious bodily harm or death, there is a duty to protect the potential victim. So information can be disclosed in this case, but only to the extent necessary to ensure the protection occurs. It is important to note that the Tarasov decision was not a consensus judgment, however. So confidentiality and the negative consequences of breaching confidentiality was a fundamental issue raised by Justice Clark, who was one of the two dissenting judges on the case. So in the decision, the judges stated, "We realise that the open and confidential character of psychotherapeutic dialogue encourages patients to express threats of violence, few of which are ever executed. Certainly, a therapist should not be encouraged routinely to reveal such threats. Such disclosures could seriously disrupt the patient's relationship with his therapist and with the persons threatened. To the contrary, the therapist's obligations to his patient requires that he not disclose a confidence unless such disclosure is necessary to avert danger to others. And even that, then he do so discreetly and in a fashion that would preserve the privacy of his patient to the fullest extent compatible with the prevention of the threatened danger." So in Australia, there is no common law duty to disclose confidential information to protect others, not even when clients threaten to kill or seriously injure another person. There is no established duty to protect, so the Tarasov case does not apply to mental health professionals here. The courts regard the importance of confidentiality as a matter of public and private interest. However, there is state-based legislation that requires disclosure in some cases, and the law does allow the discretion to disclose. Also, it is considered that there is a moral and civil duty to disclose to avert immediate and specified risk to identifiable persons. So, negligence is considered to occur when the duty of care between a professional and a client is breached. And it is based on a consideration of what a reasonable and ordinary skilled member of a profession would have done. There's been similar state laws since 2002 in regards to negligence. For example, in Queensland, the Civil Liability Act of 2003. A mental health professional is considered negligent if there was foreseeable risk, the risk was not insignificant, and a reasonable person would have taken precautions that the mental health professional did not. So while there is not a duty to warn, there are still legal and ethical responsibilities to act, to take precautions to prevent harm. And these precautions may involve breaching confidentiality. So, public law requirements. The regulatory bodies state that a breach of confidentiality can be pursued through a professional's regulatory body via administrative law. Also, regulatory bodies can take action themselves against individuals who illegitimately breach confidentiality, or the regulation authority can refer to other authorities such as the Health Services Commissioner or the Privacy Commissioner. So a regulatory agency, also regulatory authority, regulatory body or regulator, is a public authority or government agency responsible for exercising autonomous authority over some area of human activity in a regulatory or supervisory capacity. An independent regulatory agency is a regulatory agency that is independent from other branches or arms of the government. For example, the Australian Health Practitioner Regulation Agency, or APRA, is the organisation responsible for implementing the National Registration and Accreditation Scheme across Australia. So it regulates national boards for chiropractors, dental practitioners, medical practitioners, nurses and midwives, optometrists, osteopaths, pharmacists, physiotherapists, podiatrists and psychologists, Aboriginal and Torres Strait Islander health practitioners, Chinese medicine practitioners, medical radiation practitioners, and occupational therapists. So therefore, it regulates the Psych Board, the Nursing and Midwifery Board, and the Medical Boards of Australia. So legislation to be aware of or to consult when considering matters of confidentiality. In Queensland, we have the Health Practitioner Regulation National Law Act of 2009, which is in force in each state and territory in Australia. We have the Ombudsman Act of 2013. So notifications previously made under the national law are made to the Health Ombudsman. For example, a complaint about a psychologist goes to the Health Ombudsman, who then informs the board. Queensland legislation, which provides privacy and confidentiality protections for personal information, include the Information Privacy Act and the Information Privacy Regulation of 2009. The Commonwealth Privacy Act of 1988 relates to privacy and health records and outlines the legal obligations for employees to keep health records confidential. It applies to private sector and individuals. The Privacy Act 1988 now includes 10 national privacy principles. These principles set the minimum standards that health service providers must abide by when they collect, use, disclose and store your health information. So rights under the Privacy Act 1988 include that a client's privacy rights means that they should be told about what happens to their health information. They have more choice and control over their information. They can ask to see what is in their health record, and if they think it is wrong, they can ask for it to be corrected. They should be told why and when a health service provider may need to share their information, for example, to ensure they get quality treatment and care. So, which health services are covered by the Privacy Act? It is any private sector organisation that assesses or records information about a person's health, and any organisation that maintains or improves a person's health or that dispenses prescription or medicinal preparations. So this includes services in the private sector, such as private hospitals, doctors, nurses, dentists, chiropractors, disability services, physios, childcare services, social workers and psychologists. The Mental Health Act 2000 of Queensland covers confidentiality and disclosure of clients' mental health information. And you might also want to have a look at the Australian Psychological Society guidelines on reporting abuse and neglect and criminal activity. There is also the Child Protection Act of 1999 in Queensland, the Education Act General Provisions Act 2006, which was amended in 2012 in Queensland. So regulatory bodies are not to be confused with professional bodies, such as the ones that are listed in this slide, some of which you may be members of. So these bodies don't actually regulate your practice or manage your registration. They provide direction and resources to support best practice. And each professional body has their own ethical codes which direct professionals about how to manage, maintain, and legitimately breach client confidentiality. So, as part of the reflection for this week's lecture, please consider outlining some of the organisational policies of your workplace that have direct relevance to the issue of confidentiality. So, exceptions to confidentiality. As we mentioned earlier, confidentiality is not absolute. So, under normal circumstances, the practitioner is expected to exercise a duty of confidentiality, but there may be certain situations that require the practitioner to breach confidentiality. So generally, there are 5 conditions in which confidentiality may be legitimately breached. So, one is with consent of the client or the person who has the legal authority to act on behalf of the client. Second is when compelled by the law, for example, if information is subpoenaed. When there is a risk of immediate and specified risk of harm to others that could be averted by disclosing the information, or when there is risk of immediate and serious harm to the client themselves, that is the person receiving the therapy. And we also need to consider that when we consult colleagues, for example, in supervision and training, that we need to be mindful of concealing the identity of the client that we might be talking about. or obtaining their consent with prior notice. And also to take steps to ensure that both the supervisee and the supervisor will maintain the client's confidentiality. So in the case of making exceptions to confidentiality, the best practice is to inform the client of the disclosure of their information in line with the limitations. Where safety permits, mental health professional informs the client if their information is to be disclosed, what information is to be disclosed, what are the circumstances and the reasons for the intended disclosure of the information, and to whom and when the disclosure will be made. So, as noted previously, under normal circumstances, the practitioner is always expected to exercise the duty of confidentiality, but there are certain considerations that will require the breaking of confidentiality. So, the main two conditions are when the health professional is compelled by law to divulge information, for example, in a court or another statutory setting, or when there is a real prospect of unacceptable harm to either the client or others associated with not divulging information. So the conditions of the exception will often apply only to certain pieces of information and not to everything revealed by or known about the client. So, when compelled by the conditions that we've just discussed, the practitioner should only divulge the information that is either required by law or to which the prospect of real harm is attached, and all the remainder of the information needs to remain in confidence. The law may require disclosure and provide protection if disclosure occurs in certain circumstances or prohibit disclosure. However, the law is informed by moral considerations and reflects societal values, while also allowing the independent moral judgment. The focus of the law is described as narrower, and while of assistance, won't necessarily answer the question of what should one do. Whilst the law regulates much of what information can be disclosed, ethical codes and professional judgment will always be highly relevant. So in the case of grey areas where it may be unclear whether information should be disclosed, and if so, what information? There may not be a specific imminent risk. However, there may be a liability if a practitioner does not disclose information. For example, disclosure of information about a client's offending history to a prospective employer, accommodation supervisor, or support worker from a non-government organisation. Other potentially complex areas concern suicide ideation, confession to crimes, the reporting of abuse, breaching of orders, and situations involving individuals with serious infectious diseases. The general rule of thumb under usual circumstances is that the mental health practitioner must always respect client confidentiality. Distinguishing when to breach confidentiality requires judgment based on the weight of relevant considerations or factors, and it should only occur when revealing the information is essential to protect others from harm. If there is no foreseeable serious harm to an intended victim, then the practitioner should not reveal the information without consent. It may be possible to actually persuade the client to disclose the relevant information themselves to avert the risk of harm to others. And the best practice is always to inform the client that a disclosure will be made. So there are several situations which increase the risk of a practitioner illegitimately breaching a client's confidentiality. That is, illegitimate provision of identifiable information which belongs to a client. So these include social situations where there may be discussion and sharing of experiences about particular clients, gossiping using identifiable information, and the people that you're talking to are able to identify the client. Also, in education and training situations where practical examples are drawn from the practitioner's own experience, once again where the information may be identifiable. In difficult circumstances, such as working in unfamiliar context with different rules and regulations, so as a practitioner, it's very important to be careful in environments where you are unsure of the laws, regulations, and policies. During abnormal states of mind, for example, if you're under the influence of alcohol, and not being scrupulous with managing client file information. So the moral of the story is to always remain careful and mindful of client information. So implications for practice. A fundamental strategy for addressing issues concerning confidentiality is for the mental health practitioner at the outset of contact to explain the concept of confidentiality and its limitations. This is important both in treatment settings and when compiling reports for a third party, such as the court or corrective services. It is important to explain these to the client in a manner that can be easily understood and to repeat this information when consideration is being made of breaking confidentiality. It is recommended independent assessors inform the client about the nature of their relationship and that it is not a relationship in which therapy is conducted. This involves telling the client how much information from the assessment will be used. So, for example, in compiling a report for court, and during an interview, the assessing practitioner may need to remind the interviewee of these issues. Consultation with a senior colleague, supervisor, or legal advisor is indicated when it is believed there is a specific and imminent risk to the person themselves or others, and it may be necessary to break confidentiality. And clear documentation about disclosures made by the client and the basis and rationale for breaking confidentiality is a protective strategy for the practitioner. So in explaining confidentiality and its limits at the outset, you should include how the information that you collect on the client will be managed. You should allow the client to ask any questions or express their expectations. Explain what the client can expect from the service. And try to maintain that difficult balance between assuring confidentiality and clarifying its limitations. So the key take-home points for today is that confidentiality is a cornerstone of mental health practice. It is based on the principles of autonomy and justice from an ethical point of view. And this is where we demonstrate our respect for the dignity of our client and for their rights by allowing them to maintain control over their information. Conflict occurs where these principles clash with those of beneficence and non-maleficence and the duty to protect the client and others. It's not absolute. We can disclose with client consent when compelled by the law or when there is a risk of harm to the client or to others. When choosing to maintain or breach confidentiality, we need to consider our legal obligations, our regulatory bodies, the organisational policies, at the same time as considering our ethical obligations. And we need to be careful that we don't take risks that increase the likelihood of breaching client information. So, to think about a scenario, a patient on the ward has a psychotic illness. The patient's girlfriend calls the ward one day and asks about the patient's diagnosis. She states that she has read about the link between mental illness and violence and wants to know what risk he presents to her if released. So just take some time now to pause and write down your thoughts on the following questions. What are the ethical considerations in this situation? And what do you think you are able to disclose? So some things to consider. From an ethical point of view, the patient has the right to have their health details remain confidential. A right to have control over their health information, how it is used, and who it is shared with. They also have a right to the same level of control that we would expect with our health information in a health setting. We also need to consider whether or not there is any harm that could be prevented to the girlfriend through disclosure of information. And does disclosure place the patient at any risk? If there is no imminent harm likely to the girlfriend, what are our alternatives? Could we provide some general information to the girlfriend about mental illness and risk factors of violence? So we need to remember that we may not even be able to indicate to the girlfriend who rings up whether or not the patient she's asking about is even in the hospital. We can't actually verify that this person who's ringing up is a relation of the patient. It might be okay to provide her with some general information and direct her to some information that is available, some fact sheets. Talk to her about risk factors and things to look out for to maintain her own personal safety. Talking generally in this way doesn't breach the confidentiality of the client. We have no information to think that the girlfriend is at risk. So we don't have any ethical reason to breach confidentiality. So have a think about what some other ethical issues in this case might be that you would like to consider. So the discussion board post from this lecture is due on the 11th of September by 5 p.m. on the Sunday, and it is one of the 4 posts that go towards 20% of the assessment 1. It needs to be between 200 and 400 words. So in answering this question, choose a forensic or mental health or health setting and briefly compare and contrast some differences in terms of the issues of capacity, consent, and confidentiality, and consider some of the legal, organisational, and regulatory requirements that need to be managed. The question is, how might the practicalities of capacity, consent, and confidentiality be different in my work setting if a forensic health or mental health type setting or workplace I might consider working? In that case, choose one forensic health or mental health type setting, then in other forensic or mental health or health settings. These are the required readings from today's lecture. And some recommended readings that you might like to have a look at. Thank you.